All right. Good afternoon, buenas tardes, bonjour, bon dia. Welcome back, everyone. And thank you for bearing with us. We are now in episode 2 of our 4-part series, Bridging the Americas. And welcome back if you joined us in episode 1, where we examined important questions on the standard of care. And for those who may have missed it, we actually recorded that and put it on the forum's YouTube site. And the link is in the original email. And if someone would like to see it, I will just send me a note and I will flip that to you. But our plan is to put all 4 episodes on the forum's YouTube page for you to look at and to forward to others you might find of interest to this topic. So last episode, as mentioned, was focused on the standard of care, and we really tried hard to look at topics that are meaningful in terms of differences between the civil and common law jurisdictions in the Americas. So our next topic is one that is very close to many of your practices, and that is damages. And to present this, we have an amazing panel of speakers and moderated as last time by Jerry Brodsky and Roberto Hernandez. We looked high and low. We went to Canada, we went to Brazil, we went to Puerto Rico, and Jerry will introduce our incredible mix of panelists who will really draw out the contrasts as well as the nuances for you. And just to remind everyone, for those who are joining for the first time, this webinar is a presentation of the American Bar Association Forum on Construction Law. It's one of the largest groups of construction lawyers and consultants in the world. We have 13 divisions, and this is just one of them, representing all segments of the construction industry, from owners to design professionals, general contractors, subcontractors, CMs, insurers and sureties. And as a Canadian lawyer myself, the forum has been very helpful in cultivating a strong collegial network of international contacts in the engineering and construction industry, whether you're in-house to external counsel, from consultants to expert witnesses, especially for Canadian clients working in the US and Latin America, and more clients coming northbound into Canada. So if you like what you see, let me know, and I can give you more information about being an international associate. So I have the pleasure of introducing 2 division members without whom this concept would not be possible. First, we have Amy Phillips. Amy is the VP of Performance Practices of Forensic Insurance Risk Renewal and Applied Sciences at Thomas Eddy Thompson in Washington, DC, who not only helped come up with the catchy title, but also supplied the very apt picture in the brochure and behind me as well. So as the webinar starts, Amy will monitor your questions in the Q&A box and then periodically relay them to Jerry and Roberto. And Jerry is a partner and director at Peckar and Abramson's Latin American practice based in Miami. Many of Jerry's matters involve multicultural, domestic, or cross-border transactions and disputes. And as written up in a great article in law.com in December, as many of you know from the first episode, this man may have single-handedly saved the $400 million expansion of the Panama Canal from cratering in a complex dispute. So with that, I will pause here and pass the mic over to Jerry.
Richard, thank you very much. Hello, everybody. I'm Jerry Brodsky, and I will be your tour guide today. Thank you for joining us. This is episode 2 of our ABA Bridging the Americas series, and today we will focus on damages. Just to remind everybody, and for those that joined us on episode 1, as well as those that are just joining episode 2 today, the criteria for the selection of the topics for these episodes, I think, is important in understanding what we're trying to convey and the whole philosophy of this series. In selecting the criteria for the episodes, we're basing it on an understanding how, given the universality of many construction issues, legal doctrines and jurisprudence that govern law issues, risk allocation and disputes in construction, translate from common law in the US and in Canada to civil code jurisdictions in Latin America, such as Mexico and such as Puerto Rico, where half of both jurisdictions exist, but definitely a civil code exists and it governs in Puerto Rico. Understanding the civil code considerations of current issues of significant interest to practitioners and the industry is another criteria that we use for selection. And just like we did in episode 1, which focused on the design, build, risk, and the standard of care, that topic met both criteria. Today's topic, which is damages, does too. We're going to be discussing damages concepts and principles that govern damages issues in construction cases in both common law jurisdictions, like the US and Canada, as well as in civil code jurisdictions. And damages is certainly a subject of significant interest to practitioners and the industry. Our mission today and our goal is to provide a good balance between legal doctrine and practical information. Some doctrine is necessary to understand fundamental concepts in civil code, and our Dream Team cast will cover all of the important perspectives today. On the legal side, we addressing common law issues. We have Matt Alter and myself. On the civil code, we have Mariacté, Correa, and Roberto Hernandez. On the technical side, we have Paul Pocalico and Felipe Gutiérrez, who are routinely hired on cases governed by both common law as well as civil code, and they will provide insight as to how damages are calculated and presented under both legal systems. Before we start, I'd like to briefly tell you about our Dream Team cast today, starting with Mariacté. Mariacté Correa is, I just lost my screen.
It's here.
Just bear with me. There it is. Don't know what I did, but I lost a screen. Here, I think it is. My apologies, I have lost the screen with the bios, so we'll skip the bios and collect them for, address them at the end. So let's just jump right in and start the conversation by comparing common law and civil code principles that apply to both damages issues that we're all familiar with. The first topic for discussion is contractual limitation of liability and damage provisions. So I will start with Matt in Canada and ask Matt, can you explain to us how the common law treats contractual limitation of liability and damage provisions?
Thank you, Jerry. Hope everyone can hear me, and thank you, Richard, for organizing this, and Jerry and Roberto for moderating, and Amy for your stellar involvement, and my fellow panelists. It's a pleasure to join the forum, rejoin the forum, and this is a very interesting topic. I'm coming to you live from a little ski town called Collingwood, which is about 2 hours north of Toronto. We're still getting the last of the winter skiing here, but it's going quickly. So the comments I'm going to make today on several of these damages topics from the common law perspective obviously are informed from my position as a lawyer practicing in Canada. And while I have attended ABA forum programs for the past 20 years, I don't profess to be expert in US law, but I think through osmosis, I've gained quite a bit of insight. And again, the principles we're discussing are, initially, most of them are UK-based principles in common law, which the US has adapted and modified, and as has Canada. So when we talk about limiting liability and damage provisions in common law jurisdictions, as we know, contracts very often include clauses that limit or cap the defaulting party's liability and financial recovery for both contract breaches and negligence. We often see this with design consultant agreements, which include an express cap on liability, often tied to the contract fee or available insurance. Now, generally speaking, if the limitation of liability provisions are clearly worded, and if they're not offside specific legislation, that is statutes, they will be enforceable from the standpoint that common law jurisdictions generally uphold the party's freedom to contract. The Supreme Court of Canada has stated that absent legislative intervention, the courts will generally give effect to the terms of a commercial contract freely entered into. Now, there are, however, some exceptions, and parties may find some types of damages and liability are not capable of being capped or excluded. This may be the case depending on the law of the common law jurisdiction that governs a dispute, with claims based on gross negligence or willful misconduct, claims that are based in fraud. A contract term that is found to be unconscionable or oppressive or contrary to public policy may not be upheld. Very briefly, there is an Alberta case not so long ago where the Court of Appeal refused to enforce a limitation of liability clause where the defendant supplier knowingly supplied defective plastic resin to a customer who used it to fabricate natural gas pipelines and then tried to rely upon the exclusion of liability or limitation of liability provision and was not successful. So as noted, parties to the contract also need to be aware of legislation that may override the contractual provision relied upon. So while we don't have a civil code that gives blanket statements in this regard, there could be specific statutory law such as consumer protection legislation or sale of goods legislation, to name just two examples. Now, obviously, the contractual provision relied upon is critical. It needs to be clearly worded. And that said, there may appear to be a clear provision, but it may be challenged if there is ambiguity. But if the words are clear enough, and barring one of the other factors I've just mentioned, parties can and often do contractually limit their liability for breaches of contract and negligence in common law governed contracts, which I understand is something of a distinction from the civil law and civil code approach to damages.
Thank you, Matt. Let's head from the Chile North down to La Isla del Encanto and ask Mariacté to tell us about contractual limitation liability clauses under civil code as understood and enforced in Puerto Rico.
Okay. Hello, everyone. I'm Mariacté, and I'm coming to you from sunny San Juan, Puerto Rico. Today is sunny, and it usually is. As Jerry said, I thank everybody of the panel that's here. It's been great working with you, and I thank the division, of course, and particularly Jerry for inviting me to participate today. Now, as Jerry mentioned, Puerto Rico is a mixed legal system. So we have the common law and the civil law tradition, both very vivid and active, in this jurisdiction, and neither takes precedence over the other. I will focus on the Puerto Rico Civil Code of the matter in comparison to what Matt is going to talk about on the damages topic. So I must mention that we have a brand new civil code here in Puerto Rico that substituted the 1930 civil code. Incorporates all the dispositions in the old civil code, but it has also brought in new amendments that are have also been enacted in other Latin American countries, like in Peru and Argentina, particularly those from those civil codes in those two countries. It also incorporates some of the jurisprudence of the Puerto Rico Supreme Court that has interpreted the prior civil code. So embedded in that we will have some common law doctrines that have been, have been interpreted and used throughout the years. And so today we have all that mixed up in the civil code. Now, going to the question about the limitation of liability, we know that under some civil codes, the parties are not so free to agree as to financial consequences. Those financial consequences are established in the code. So you have to go to the code and to evaluate whether you are able to limit or not limit the damages, right? Any contract clause that is contrary to what the code establishes then would not be considered valid, and you can't enforce it in any court of law. Also, the importance of looking at the code before you do anything is because you will find some instances, some provisions that allow you to contract otherwise, to go around those limitations that the code establishes as to any topic, when they insert the words, unless the parties agree otherwise. Okay, so it is possible to contract otherwise, but only if the code allows it. As regarding the limitation of damages, I must mention that the civil code has, in Puerto Rico, has a strict liability provision to various actors in the construction contract, the developer, the contractor, and the designer, for the 10-year warranty period. Okay, that is a tort, right, action for damages or any defective work as to third parties. Okay, it also has that restriction within the construction contracts section of the code, and that's a contractual restriction between the owner and contractor and designer. Also, that there has to be a warranty limit of 10 years. So any contract clause that you include, between the parties, limiting those damages would not be considered valid. There's another example where you are able to limit the damages for the owner, and that's under the construction contract section. You see, because the code has a general part of general contracts and obligations, and then it has another section for construction contracts. So in that section, there's an article that allows the termination or resolution of the contract when necessary changes in the project increase the value of the project by 20%. It establishes that percent. So if the owner sees, the value of the project is way beyond 20% increase because of the many changes, the owner can terminate the contract, and limit that way damages therefore. So
thank you, Mariacté. We can already tell by the two answers that your comments and Matt's that there is a significant contrast with respect to limitation of liability clauses. Let's head west a little bit and ask Roberto. Roberto, what has been your experience with limitation of liability clauses in Mexico and elsewhere in Latin America?
Hello, good morning. Mexico, since we have weather reports in Mexico, it is sunny.
Good.
Thank you very much. Thank you, Jerry. Yeah, well, as you know, in Latin America, we have civil and commercial codes. We were speaking that with Mariacté, and it's a very interesting situation. What do we include in civil codes? What do we include in commercial codes? In civil codes, we have the general rules for contracts, and in some jurisdictions like Mexico, you have in the commercial codes commercial contracts that could be different from the civil principles, and this is the first thing. But one thing that you have in common in both kind of codes is that the will of the parties is the prevailing motive for the interpretation of the contracts, and therefore, if and unless you have a specific provision, like Mariacté says, that limits your the possibility of keeping the liability, then you will be able to cap it. Mariacté spoke about this specific way of some provisions cannot be breached or have to be fulfilled. That's what in many countries we call public order. And it's a little bit difficult to understand from a US perspective, because when you understand public order, you feel more like a government size, government oriented. But in Latin American countries with civil code, we have these very specific provisions that are mandatory, and therefore you cannot even if you waive them, you are not able to waive the waiver to be valid. So
Enforceable. Yeah.
Enforceable, exactly. Thank you very much.
Mhm.
So you can enforce it. This is, for example, one of the cases of the decennial liability, the 10 years that Mariacté spoke. There are different ways of interpreting. Some jurisdictions apply in the sense that the decennial liability, the 10 years, cannot be waived, and the others say that it can be waived. Of course, this is a public order rule, and public order rule, for example, in Mexico, are subject to the judge's interpretation. So it is very difficult that you will find the provision that says this is a public order matter. You have to look for every provision and see how it is drafted and what the court says. So the first takeout is that is the will of the parties that may limit the liability. Second, that you will find public order rules that may impose liability even if there is a will of the parties. And third, that will require a lot of attention to the criteria of the judges to know if they can be waived or not in order to be enforceable. And that is the way, in some way, it works, Jerry. Thank you.
Thank you, Roberto. And clearly, I think your dog agrees with you, what you were saying.
Always, if he doesn't, I will not feed him.
That's those are the times we live in, and we just roll with the punches. It's all great. Thank you. Let's now turn to a fan favorite topic, at least for us here in common law jurisdictions, and that's the P word. I think that not the first day of law school, but the second day of law school, they tell us you cannot have a penalty clause in a contract. It's not enforceable. And that's ingrained in our lawyer DNA. So let me ask Matt, why are penalty clauses generally unenforceable under common law?
So Jerry, this is another concept that we inherit from the UK, I think originally Chancery courts. And the common law doctrine or prohibition on penalty clauses has found that an attempt to impose a penalty on the defaulting party is generally found to be void and unenforceable, as it's said to be contrary to public policy and equity, since the intent of a penalty is to inflict punishment. So the common law approach is to consider the measure of the prescribed compensation for the breach in contract with the actual loss or failure of performance by the defaulting party in assessing whether the stipulated measure of damages is in fact a penalty, even if the word penalty is not used. So in lieu of penalties, and most of us common law practitioners know this, liquidated damages are often used, at least in delay claim type instances, as the measure of damages, as a genuine pre-estimate of the damages to be suffered by the innocent party. So let me repeat that. They must represent a genuine pre-estimate of the damages to be suffered by the innocent, that is the non-breaching party. And its value is assessed for legitimacy in relation to the overall enforcement of the contract, in that it is not to be extravagant, exorbitant, or grossly excessive. Now, like all common law rules, there are exceptions, and the court's approach to these types of provisions is somewhat nuanced and changing each year. Courts recognize that their power to strike down penalty clauses is in essence an interference by the courts with the party's freedom to contract. And I mentioned at the outset, common law courts don't like to rewrite contracts. They want to enforce and uphold the party's commercial rights to contract. But there are instances to provide relief against oppression that the courts find they have this jurisdiction. And they look at this through the lens of unconscionability or through the application of the equitable doctrine of forfeiture. But the bottom line is, if you're drafting contracts for common law jurisdictions, you simply avoid using the term penalty.
Thank you, Matt. As we head south and cross the US, in the interest of time, I'll say ditto. And we head down to Puerto Rico, Mariacté. How do civil code jurisdictions treat penalty clauses in contracts?
Well, it's also a big contrast. In civil code jurisdictions, penal or criminal clauses, how they're also called, are valid and are codified by law. There are articles in the civil code dedicated to the penalty clause. So the code allows for a construction contract to have a liquidated damages clause, known in that particular provision of the code as pre-calculated damages, and a penal clause. You can have both. In both cases, damages do not have to be proven. The condition occurred, meaning the partial breach at a certain stage of the project. Damages under the penal clause are due. Penal clauses can impose a payment of certain amount. It can also be the loss of a certain benefit or any other penalty that is agreed under the contract. So the code establishes exceptional cases where the courts can modify a penal clause if the case demonstrates an extreme economic disproportion of the penalty. But then again, you would have to litigate that. And then, so, in contracts in Puerto Rico, those clauses are valid and are negotiated. So it's, when you go to negotiate a construction contract in Puerto Rico, you have to be mindful that they are valid. Then you have to do the best that you can when negotiating to see that the pain is not as bad. That's, as far as it goes.
Thank you, Mariacté. Roberto, is that consistent with your experience in Mexico and elsewhere in Latin America?
This is very interesting because when I learned about the concept of penalty in the US, I was really surprised. Because in Mexico, for example, we have like the predefined amount for what we call a pena convencional. You spoke about it, Mariacté. You said conventional clause, or what was?
Calculated damages?
The damages.
Yeah, recalculated, yeah.
So there's a penalty clause.
It's the same thing.
Pre-calculated damages. So you don't have, as Mariacté says, you don't have to prove that it was the actual damage of the breach. It is a pre-established amount. And as far as I understand, this is more related to what we understand as penalty in the US, that you have to really prove that the damages are related to the breach. And therefore, if it's very low or it is high, and I will speak about the cap, that's a different thing. In fact, when you negotiate a clause, is more like this liquidated damages clause in Mexico is more like the standard of the practice rather than what are the actual breach effects of the breach. And for example, if it's being a day delay in determination, it will say, well, this is high or low, but depending on what is the practice rather than reality. This is the first thing. The second thing is that liquidated damages in Mexico exclude damages and losses. When you're speaking about the same breach, for example, if there's a breach that it has included a liquidated damages clause, then you cannot claim damages and losses simultaneously for the same breach. And the third thing that is important is that the liquidated damages clause is capped up to the amount of the obligation that is part of that breach and condition. So for example, there is a breach of delivering a specific part of a job, and that job is $100, let's say. The liquidated damages or penalties, what you can want to call it, cannot be higher than $100, and that is our cap established in civil code. So there's different rules, and this is one of the public order or public policy matters that will, when you take to a court, they will say you cannot exceed the penalty clause, or you cannot get damages and losses, and that is very predefined. That is not a matter anymore of discussion, and I think it's a permanent criteria. So that is.
Thank you.
Thank you.
Jerry,
Yes.
I just want to add something with regard to that contrast. So another thing just for viewers to recognize is that, and I think we're going to get to this point, but in common law, damages for a breach can't be speculative. They actually have to be proven. There has to be cause and effect, and they have to be proximate and all these other tests. So one of the benefits of the liquidated damages approach in contracts, of course, is that it is a pre-approved, pre-stated sort of expected loss amount that the owner can then apply via set-off without having to prove necessary entitlement. So that's one of the benefits of a liquidated damage provision, as opposed to a general damage loss, is the owner's right to then apply a set-off or back charge as they may do during the life of the contract itself. So that's obviously a risk for a contractor, but it's one that the contractor has an ability to assess at the outset. With unknown and uncapped liabilities, the contractor is in a bit of a box in terms of how it's going to price contingencies or look to insurance or otherwise guard against those risks.
Thank you, Matt. Thank you for making that important point. I'd like to turn to Paul now and go from theory to practice. And go back and recap what we've heard from Mariacté and from Roberto and from Matt. And particularly the complexities of having to deal with and consider penalties and liquidated damages when acting as a forensic expert on damages. So Paul, please give us your perspective of what really happens.
Thank you, Jerry. Again, it's really interesting because anytime you are assessing damages, it's driven by the facts, and that factual determination often involves very complex data and economic issues related to the project. Many times in cases, the parties look to the experts, and the arbitrators and the panels look to those experts to get those opinions and understanding. You always have to establish the right to the damages. You're typically in a common law practice justifying the type and amount of the damages that you're requesting. And now you've heard that there are often these other contractual provisions that can allow penalties, and they're enforceable. So this creates some pretty significant exposure when you're responding in a case, and you may not be familiar with how these civil code jurisdictions enforce such provisions. I'll give you one example, which kind of brings it home. If you take a typical wrongful termination case and a claim for that termination, it's wrongful, it was done improperly. In a simple case in the US, you may be dealing with a situation in which the contractor was terminated late in the game and very far into the contract. As such, those damages are limited to the lost profits on the uncompleted work. That's a typical remedy in many cases. If you now go to a civil code case, you have additional complexities because you're dealing with both potential liquidated damages and a penal sum. Those could be very significant dollar exposures because you have both the pre-calculated liquidated damages and now a penalty sum that is enforceable. So whereas you could be dealing with a very small loss profit amount, you could be exposed to significant dollar losses in these cases.
Thank you, Paul. Let's shift subject and let's go back north. Matt, can you describe some other types of damages that are often excluded or limited in contracts in common law jurisdictions?
Well, it's common for construction contracts that are subject to common law courts to exclude indirect, special, incidental, and consequential damages, such as losses for loss of productivity, loss of profits, loss of opportunity, and interruption of business claims. The common law courts have interpreted consequential damages as being losses that do not arise naturally from a breach and instead arise from special circumstances that the party in default was not or could not have been aware of when the contract was entered into, as opposed to direct losses, which are categorized as losses that arise naturally from the breach of contract. However, if a loss of profits, for example, is a direct and foreseeable loss for the innocent party, then a clause excluding liability for indirect or consequential losses may be ineffective to exclude that liability unless it expressly refers to a loss of profit. So as a result, it's again imperative that the contract wording is clear regarding the types of damages that are to be excluded. And finally, I just add that in lieu of an innocent party's ability to recover such losses from the defaulting party, whether it's the owner or the contractor, insurance coverage is often looked to and needs to be carefully considered at the contract formation stage in light of these kind of limitation, exclusion of a variety of damage provisions that you'll find in many contracts.
Mariacté, how are consequential damages dealt with under civil code? And is there a distinction between direct and indirect damages like Matt was just describing?
Yeah, well, in the civil code, particularly in Puerto Rico, the consequential damages are codified. There's an article that establishes that a breach allows the claimant to recover not only the amount of the actual loss, the lucro cesante, that's what it's called in the code, which is the amount of damages that could have been obtained if the obligation had not been breached by the other party. So, I mean, they are allowed, I mean, under the code. If you limit those somehow in the contract, you're gonna have to, I mean, you're gonna have to fight it in court against the code that allows for the party to, you know, to describe them as a direct consequence of the breach. But it will be a matter of interpretation to the court to decide whether the, you know, the damage that you're claiming, although is not defined in the contract, in the construction contract that you are, you know, it's in controversy, whether the facts establish that it's a direct consequence, and then you can claim for them. So it's more of like a matter of proof when you get to claim those.
And let me follow up, maybe for you or Roberto or both. Is this one of those code provisions that you can contract out of?
Well, no, at least in Puerto Rico, it does not. It doesn't have those sacred words that you that I mentioned in the beginning. You know, unless the parties agree otherwise, that code provision does not have it. So you cannot contract out of it.
Yes, the damages and losses have to be, according to the civil law code, a direct and immediate effect of the breach, or the cause, like for example, what we call the extra-contractual, which is like torts. Am I right, Mariacté?
Mm-hmm.
So
Torts, yes.
The damages and losses should be direct and immediate. We don't have these indirect consequential damages. So for example, if you have a damage for the breach, you can only claim for the damage itself and the losses that are related directly, and not to the indirect loss of business opportunity, et cetera, that will be unlimited in certain jurisdictions. Another thing is that, for example, some courts and in Mexico have recognized a specific kind of consequential damages, which are punitive damages. And this is a very interesting matter because punitive damages are not necessarily included in the civil code, but they were reflected as a way of an example for the person that suffers the breach to be compensated for it. So I think the main difference, as Mariacté saying, is that we have very strict rules for the limitation of the liability and the damages and the losses that you can claim. And of course, as Matthew says, also part of demonstration that you have to give to the court, because these are not automatic. The court and the judges have to determine which are these direct damages, where are the direct losses, and how do they apply.
Exactly.
Thank you both. Next on the list of the key principles for damages is the causal link between the claim breach and the claim damages. Some of us spend a significant amount of time in our careers dealing with that issue. So let me go to Matt. Where does that requirement for the link between cause and effect originate from under common law? Please tell us.
So we're starting to hear some of the similarities and differences between common and civil law, and I'll be interested to hear the responses on this item. So the concept is founded on the principles of proximity and foreseeability between the breach and the damage, whether it's a breach in contract or through negligence, or to put it another way, the absence of remoteness. Generally speaking, the common law requires the claimant to show that the damages claimed have arisen as a direct and foreseeable consequence of the defaulting party's breach. And to recover damages, the innocent party, the claimant, must establish that it has in fact suffered the loss claimed and that the loss was caused by the defaulting party's breach. And it's the innocent party, the claimant, the plaintiff, who has the burden of proving both the fact of the loss and the causation of the loss due to the alleged breach of contract. So for example, if an owner alleges that the contractor's default, whether it's delays or defective work, have in turn delayed some other work being performed on site, then the proof of causation between the two works must be proven by the owner who's asserting the claim. It's also important to note that since delays on construction projects in particular are not unusual, the mere existence of a delay does not in and of itself necessarily mean that one party or the other has wrongfully caused a delay. However difficult it may be, the owner or contractor asserting the delay claim is the one who has to show that it actually suffered the loss and that the loss resulted from the other party's breach. And this is why concurrent delay events often pose a particular evidentiary burden on the claimant to establish that the reason for the missed milestones or negative change to a critical path were the result of an owner's acts or omissions and not due to some other cause, including its own conduct or conduct for which the owner is not responsible. So proof of causation is a common obstacle that Jerry just referred to and burden on contractors to prove in construction disputes. Due to the several layers of activity by the owner, the contractor, subcontractor, supplier, design professionals, there may be a dispute about which party caused a loss, to which degree, whether another party's acts or omissions interrupted causation, whether reliance by one party on the proper performance or duties of another was reasonable. And I would say these are all the reasons why we as construction lawyers look to retain people like Felipe and Paul to help us out, particularly with critical path analyses and concurrent delay events in order to establish this nexus of cause and effect to be successful with a claim.
Thank you, Matt. I think that causation is one of perhaps the purest of doctrines in common law, which has been the least modified or codified to any extent. So it's a great topic for contrast. Let me ask Mariacté, what are the differences between the two legal systems with regard to the requirement of causation, cause and effect, as well as the precision of proof?
Well, you know, in most civil law jurisdictions, and particularly here in Puerto Rico, aside from the strict liability provisions that are in the code for damages during, for example, the one that I mentioned earlier, the warranty period, the general contract section of the code contains provisions related to foreseeability. So there is a requirement in the civil law for damages to be reasonably foreseeable in tort negligent claims as part of the test of the duty of care. So the concept of legal foreseeability exists in the Civil Code, and it's codified in various provisions. The particular provision that talks about the foreseeability establishes that the good faith debtor in any obligation. So this is a general, it's a general provision that covers, general contracts on obligations. That good faith debtor is not in bad faith or in dolus, okay, when involved in the breach of the contract. So the good faith debtor will respond for the damages that were foreseeable at the time of the execution of the contract. So that's limited to the foreseeable damages when you executed the construction contract. In contrast, the debtor in bad faith, which means the one that acted with dolus, will be liable for all damages that may be derived from the breach or non-compliance. Thus, the limit of foreseeability applies only to the good faith debtor. Nevertheless, the bad faith will have to be proven. Okay, it's a matter of proof that has to be shown, and it'll, if you think about if you're a procedural or litigator kind of attorney like I am, that means that it'll be hard to prove through summary judgment. You will have to sit your witnesses, and that's where these people, Paul and Felipe, are very important as well. When you want to prove those other damages that were, that you want to claim against the bad faith debtor.
Paul, Felipe, you guys are doing great. You got 2 plugs on just this question. That's awesome.
Yep.
And I'll get to you guys. I'll get to you guys in a moment. But I wanted to stop by Mexico.
Thank you.
Make a stop over in Mexico and ask Roberto, how far does this go? Are there any limits in terms of, under Mexican law, in terms of the causal relationship between the claim breach and the specific type of damage that's being claimed?
Jerry, I promised to send to the group and our participants a very interesting criteria from the court that it's called damages and losses. They will be immediate and direct consequence of the facts that are caused the damage. And this is very interesting because, and I will do the translation, because it explains what it is about all the criteria from the French code and the English code, Spanish code, sorry. But going to the main point in the practice, I would like to focus on something. We had a case some years ago in which one of the parties breached a contract, the other one sued the first one for that breach, and there was an evidence of damages and losses. However, the damages and losses were not demonstrated in the evidence. There were documents that said that, for example, damages and losses were caused by third parties and were paid by third parties. So when you have this kind of evidences under civil code, if another party demonstrates that they paid and it's not affected party, even if they had the right, they will not be able to collect. And this is an additional burden. It's not only because the damages and losses and the connection, but the evidence, to prove that the person that was affected really got that damage, paid for the damage, and then he's transferring that to the person that caused the breach. So it's very similar in the sense of direct and immediate, but I wanted to share this because this was a very bitter experience in the sense of there were no evidences that allowed the affected party to get recovery of their damages and losses.
Thank you, Roberto, and thank you for sharing that with us. It's interesting that here on this particular issue and topic, there is commonality, because the concept of foreseeability and the nexus, whether codified or done by jurisprudence, somebody's going to have to make a decision as to whether it was reasonably foreseeable and whether the nexus exists. And it's the same test. Neither system provides any particular or mandatory way in which you accomplish or make that link. So let's head down to our experts and ask first Paul. When you calculate damages, there's always consideration as to the burden of proof and the nexus of the claims to the facts. In your experience, is there a difference in the civil code as compared to common law that we need to understand? You're muted.
You're muted.
Trying to avoid the background noise, so I apologize. Jerry, think of it this way. We're all really familiar with reasonable certainty. We can argue what that means, but it's a concept that comes up in common law. And we know that that proof does not rise to the beyond all reasonable doubt standard that applies, for instance, in a criminal matter in the United States or England. In my view, I would offer that the civil code cases, you're dealing with what is really a more liberal set of standards. And I don't mean that by virtue of it's easier or harder, but the case literature would offer that some civil jurisdictions have limited or no defined standards of proof, and they grant judges some extensive leeway to determine damages. Certain Latin America legal systems have developed dynamic burdens of proof, whereby a judge can redistribute the burden among the parties, depending on which party is in better position to prove or provide evidence on a particular claim. When I'm a damage expert in a case, I really feel like I have to understand the inherent nuances of these legal proceedings. I talk to the lawyers a lot about that. In the US, we have at least 50 state jurisdictions, and they have some really different rules, but damages are treated very similarly in the way they're applied and how the standards are done in somewhat of a uniform manner. In these civil jurisdictions, the judge can completely change the standard of proof that you may be familiar with. He can shift the burden, or she can shift the burden. So you've really got to prepare your claim in a construction case in a way that you're not left without evidence based on these rulings. And experts need to understand this unique aspects of these procedures and prepare what I think are some twists and turns that come out of these cases.
Thank you, Paul. Let me stay with you for a moment and ask you to give, we've heard from the lawyers. Now, I'm going to ask you to give us your perspective as a forensic expert on foreseeability.
Sure. Damages must flow from breach and the ordinary course of events on a contract. That's pretty much what's there. And there are always special circumstances that are in play that you have to be cognizant of. The common law jurisdictions, foreseeability is often used as a standard that must be met. Civil law jurisdictions do not necessarily refer expressly to foreseeability. It's in there, and yes, in some it's codified, but the courts and the comments often rely on the requirement. The concept of foreseeability acts as a potential limitation on the dollar value of the damages, as Roberto indicated. There are these nuanced foreseeability aspects that you really have to look to see what must be paid. In the civil systems, damages are generally recoverable only if they were foreseen or ought to have been foreseen at the time the contract was made. So you're going back to the concepts that we've talked about and we've heard about from the lawyers, and you must calculate them under those standards.
Okay, thank you.
Thank you.
You've spent most of your practice in Latin America, and what we've heard is that to some extent the civil code may place some constraints, or in other cases allow judges to far more freedom to shift burdens and alter the burden of proof. So as Paul was describing, what has been your experience in terms of the level of proof required and the ability of forensic consultants to meet that burden of proof in civil code jurisdictions in Latin America with those constraints?
Thank you, Jared. Thank you again, just everybody for the invitation and for the opportunity of being here today. It's a great pleasure. Yeah, and coming to your question, Jerry, I've been here for the last 5 years, and before that, I have had some exposure to what is done.
Wait, where's here?
I'm so sorry. Here in the U.S. Yeah, like people are supposed to know me. I'm so sorry. Yeah, I'm Brazilian by birth. Spent most of my life in Brazil, but also live in many other places of the world, and have been living in the U.S. for the last 5 years, a bit more, almost 6 really, which has given me the opportunity to kind of experience both sides of this profession, working as an expert, mostly in construction disputes. And it's interesting to see that when it comes to standards of proof, the requirement is not, I don't see it from an expert perspective, that much difference in the requirement in which, what you need to present and how you need to present your proof, your documentation. It's all based on facts. So if you're here or if you're in Latin America, facts will prove your damages much better than anything else. And what I do see in terms of difference is that because those aspects and that the profession is being I don't know if coded, but it's been supported best practice by existing protocols here in the civil in the common law world for longer. There's a better understanding of how to do it, how to use methodology, how to present your proofs. So in terms of requirements, really, if you present something that's real, like it's about the project, it's very specific, it's based on documents, based on facts, then your case is going to be much stronger from an expert perspective, right? On the other way around, if you go and start using industry standards and KPIs or just an indication of what's going on and not really talking about their specific project, then you're going to have a lower chance of proving your damage. So I think that this kind of understanding in the common law world, it's better commonized, so people know it better and it comes across more easily, I guess. And it can be for many reasons. One reason that I do see is that also, I think Roberto started mentioning it at some point, is that in Latin America, the economies are smaller, so there's less of each thing. So in the US, you have so much of everything that people can really specialize and do the entire careers based on, like a delay analyst, for instance. You can have somebody doing only delay analysis for 30 years, and that's not uncommon here. In Latin America, you don't find that. It just doesn't happen. So if you go to you start working as a quantum expert or as an expert on construction cases, you will more often than not also do much more types of work, which gives you less opportunity to specialize in it. So it's just a matter of having more or less opportunity to doing more or less of the same thing, I think. So I see a lot of progress across Latin America. So there's a lot more specialization with the big firms migrating to Latin America. I see a lot of good practice that is being shared across the board, but it's still you still get to see as well a lot of reports, expert reports that are based more on this is what I think it should have been. This is what it looks like. This is what I have seen. Even this is what I was told by the client. It's not really fact based. So all those differences, I think here is more, again, it's just more difficult perhaps to do, but easier to understand and to follow. So
Felipe, it's amazing how you read my mind because you mentioned specialization. It's truly amazing. And I was going to ask you what your experience is in terms of the level of specialization between experts that you've worked with and against in civil code jurisdictions as compared to what you've learned since you came to the US, and more specifically with regard to the interaction between clients, lawyers, and experts.
Okay. Yeah, that is also, as I think was a natural kind of flow of the matter, of the topic at hand, because it does make a difference, and not only in terms of experts, but also in terms of lawyers, and there's another layer of understanding that needs to be put in discussion, which is the big difference there is between normal litigation, national litigation, let's say in Brazil or in Mexico or anywhere across Latin America, then of arbitration. I'm just talking about national arbitration right now, which does allow much more flexibility and much more access to international experts. So you can start to see more and more of the let's say best practice being used across Latin America, and then have international arbitration, right, where the players are the normal like big players, big law firms, big international expert firms be involved, and then you see a much bigger approximation to what is seen in the US in these kind of cases. So in terms of specialization, the entire environment makes a difference in my experience. So if you get like a normal national litigation case, I'll say in Brazil, because I'm Brazilian, so it's, I hope nobody gets annoyed at me, but if you go to a judge case, right, it's a local litigation case in Brazil, chances are that the level of specialization in construction, that's what I do specifically, chances are that there's gonna be none, right? So the judge deciding and hearing the case will not understand a lot about construction, might have never done it before, and sometimes they're dealing with huge cases where they have to to listen to what the party appointed experts, which in Brazil they're called assistentes técnicos, and then they have to pick a perito, which is the appointed judge appointed expert to listen to hear the case, and he doesn't just for the lack of specialization, for the lack of the opportunity of doing it many more times throughout their careers, they will not understand the need for a more sophisticated or more specialized, I should say, analysis of the case and of the way the report is presented and the way it's backed and supported and so on. So it turns out that sometimes I would even say that too sophisticated might be detrimental to your case. So if you come up with something that's too sophisticated in a national litigation case in Brazil, and you start talking about, like I think Matthew mentioned the in the delay cases when there's just forgetting the name now, but when it's so commonly talked about. But anyways, when it's too sophisticated or too complex, you might end up being in a position where your case doesn't come across well, and if it's not understood, what's the point, right? So simpler might be much better than more complicated.
Yep.
So you have to take into account all those matters when you're putting together even your ideas and discussing that with the lawyers and telling them what you want to do and so on. So yeah, it's been interesting being here to see all those differences.
I think that one of the takeaways from what you've just said is what we all know: you have to know your audience, and present to that audience with that understanding. Shifting to the last doctrine relating to damages that we're going to cover today, it's mitigation of damages. So let's go north. Matt, what is the duty to mitigate in common law, and at what point has a party met that duty?
So for this audience, this is going to be old hat. I would say the mitigation of damages doctrine or principles, like the cause and effect, is probably one that hasn't changed much over the years. Mitigation typically the concept of mitigation is simple. The proof of mitigation, not so much. Mitigation typically requires the innocent party to take steps to reduce the amount of damages it will suffer as a result of the defaulting party's delay. So if a party is shown to have failed to take reasonable steps to mitigate damages, it may be found to be denied recovery of some of its damages. So again, the emphasis is on reasonable. The mitigation principle is sometimes expressed as a duty to take all reasonable measures to mitigate the loss caused by the breach. Other times it's expressed as a consequence of the rule that there must be the existence of loss and causation before the innocent party is entitled to recover, with the result that a loss that is actually avoided or avoidable, or which could reasonably have been avoided, is not recoverable because the loss does not exist or was caused in effect by the innocent party's inaction, not by the defaulting party's wrong. Now, the proof is another matter. The extent of mitigating steps that the innocent party must take is a question of fact, and the steps are those that a reasonable and prudent person would ordinarily take in the course of its business in like circumstances. And in addition, if the innocent party does reduce its damages attributable to the breach, then it can only recover the actual damages that it has ultimately suffered. And this is, again, an extension of the general rule I mentioned earlier, that damages in common law cases can't be speculative. They actually have to be provable actual losses.
Thank you, Matt. Mariacté, does the common law doctrine of mitigation of damages have a civil code equivalent or a counterpart? How do civil codes treat the concept of mitigation of damages? Please tell us.
Well, we didn't have a provision prior to the new code, but now we do, because the doctrine of the mitigation of damages had been adopted through jurisprudence, right, of the Supreme Court of Puerto Rico. And now with the recent amendment, I mean, the new, not amendment, but the new civil code completely reenacted now in November of 2020, we have the mitigation of damages doctrine embedded and is seen in a specific provision. It is seen as a modality of contributory negligence. Okay, that's how the Supreme Court has interpreted in the tort jurisprudence. In addition to that, we do have, I like to say, hidden mitigation of damages concepts in the special contracts section of the code, and in particular in the construction contracts. There are a couple of mitigation provisions that are imposed as part of the contractor's obligations, and in that article, for example, the contractor has the duty to alert or advise the owner about the bad quality or inadequacy of materials provided by the owner. So, you know, if the contractor needs to do a claim afterwards, you know, during the project, it has to have shown that alerted the owner saying these materials are not adequate, right, are not appropriate. So, you know, there's an obligation to mitigate damages as far as the materials goes. And another example is the contractor has to allow owner to verify the project status, check the quality of materials, the work performed. So there, the burden is on the owner. The owner also has to be checking up, you know, the status of the project, so that, you know, later on when the claims arise, mitigation has to be proven, you know, that you did take the steps to control the potential damages at the end of the day. So, you know, just like under common law, it is a requirement of a plaintiff's claim to show that it took steps to minimize the effects of the other side's breach in an effort to reduce the impact of the damages.
Thank you. And so we get to discovery and the lack thereof. it's for us, U.S. practitioners and common law practitioners, the concept of discovery is so fundamental that the concept of not having it is shocking sometimes, at least when you first learn that you're not going to get to see any of the other side's documents before you go to trial. So, Felipe, tell us, what are the main challenges that you face as a hired expert in a case, trying be in a civil code jurisdiction where there is no discovery, at least not the way, not like we know it in common law jurisdictions? Is it always, trial by ambush, by surprise? Tell us, what's been your experience?
Yeah, it's funny. It's funny because, and again, think about the audience, right? So you interestingly mentioned that it's a surprise when, for in the US, right, for lawyers to understand that somewhere else, like in Brazil or across Latin America, you don't really have the discovery at your hand. Like it's not there almost. And for me, it was the other way around, right? So I remember when I first heard of it, I was going like, oh my God, so many possibilities all of a sudden, because you're gonna have access to the information, like again, know what they were talking about, this specific issue, and it was like it was a change. It was an eye-opening thing that first time I heard about it was really interesting, and you're right, especially if you are in the defendant seat and you're not gonna have the last word. It's tough because you not only you have to answer a claim with the information that you have to guess what the other party's documents are, if they're hiding anything, and they will be hiding some stuff, probably. So there's a lot of strategy that goes, especially from the lawyer's perspective, but we help with the understanding, especially in construction, with the understanding of what kind of documents should have been, what kind of information probably exists. So there's a lot of interaction with the lawyers on that sense, and I think that's a nice input we can provide on those cases where discovery is really not there. I mean, there's some, especially with international arbitration, again, you have more access, and IBA rules and stuff like that helps you getting some level of information if you can prove it's relevant for the case. But in a normal dispute, like again, local litigation, there's a lot of guessing and hoping. There's that as well, right? You go like, look, they might have this kind of information, they might have this piece, but from what we've seen or from what we know of that client or of that sector, they will not, or they will have this kind of information. So there's just more, I guess, more uncertainty from that perspective.
Living, picking apart the other side's financial documents and damages documentation. Some of us have the fortune of seeing you do it and have been a part of that. So with that background, how do you deal with the complete lack of financial information and backup from the other side in civil code jurisdictions?
Thanks, Jerry. I guess, I always go back. These are great lawyers that I work with, and they have this wonderful motion practice in the US. And I've signed more affidavits trying to get documents than I can remember. And I've gone to hearings and argued and seen the judge and the panel ferret out the source. But you have to remember, in a construction case, there are always documents. Probably more documents than you ever imagine when you really dig in from the accounting side. And those may not be the exact documents that you're required to present or refute a damage claim, but in my experience, there's certain things that are always there. Project billing files, there's money that flows back and forth. There's usually progress bills. There's usually some daily reports, and those things are relevant and they contain important data. We're called forensic accountants for a reason. We kind of piece together this missing information. I also want people to realize I just never get called when the job goes right or perfectly. There's always a dispute. So I have a lot of experience on bad construction projects, and bad construction projects that are document issues, be they a common law jurisdiction or a civil code jurisdiction. Let me give you one example. We were retained in a case to defend a group of 5 contractors that were alleged to have rigged bids on a series of local construction jobs. And these allegations were premised on a theory by the government that the bids seemed improper and that they had been done in a way to split up the work among this group of 5. And the government had allegedly seized records from one of these perpetrators that we never got to see. And these weren't sophisticated or large contractors. These were, mom and pop operations that had, a good track record. And, there weren't like a lot of files. This was not a sophisticated computerized accounting and data, but we did get the bid files, and we found and were able to obtain their cost records, which were pretty rudimentary. But with that data, we were able to kind of work through the information, and we concluded that these bids were done based on the geographical proximity of the contractors to the work. And the margins were pretty reasonable and within the typical ranges for similar work. So somebody who's rigging bids doesn't do it to just make a reasonable profit margin or a small profit margin. So that evidence was really enough to kind of put these allegations to bed and show that they were without merit. So utilizing, simple documents, you can really go a long way in these cases. And it's not what you always like, but it's what you have. And as Felipe said, it's hard for people to understand this. They don't understand it. They can't just see the information or gain it. So I'd say you can still make a pretty solid case and argument even with the limited information. Great.
Thank you, Paul. Now, before we close the session, first I want to again apologize for not doing the presenting my dream team panelists. I lost the screen somehow. When you have 4 screens and you just lost the information, but and I'll apologize again because I'm not going to use the last few minutes to go over that. I will ask you to please go to the website and learn a little bit about the great talent that we've had on today's panel. With that, I'm going to ask everybody to close your eyes for a moment and imagine you're in a place called the legal Galapagos, where 2 legal systems coexist side by side without prevalence. How would that work? Would the 2 systems stay completely separate, or as Darwin taught us, would one legal environment affect or impact the other over time? Let me ask Mariacté, who lives in a place just like that. It's called Puerto Rico, where the 2 systems coexist without prevalence, and to comment on the Darwinian effect. Can you give us examples of ways in which common law practices and procedures have been incorporated by civil codes in Puerto Rico, and vice versa, if any?
Of course. Yes, it's a perfect example of how through time, as since, before we were a Spanish colony until 1898 when the U.S. Army invaded Puerto Rico and we became a territory. And since then, the legal system has been changed through time, but we still kept many of the civil law traditions, the civil code, the mercantile code, but the court system was changed through time, and at the beginning was the military changes to military courts, and then afterwards, once the Constitution was enacted in 1952, then the Constitution created the judiciary, branch. So now we have a very similar judiciary to the U.S. actually form, except that we don't have we do have bench trials in civil cases, right? Not jury trials in civil courts that are the general jurisdictional courts of Puerto Rico. So you see that the procedural, the rules of procedure, of civil procedure, the rules of criminal procedure, and rules of evidence have been enacted similar to federal rules. Okay, so you have procedurally a form of judiciary that assimilates the U.S. Legal system, and then but you still have the substantive law of the code and the mercantile laws and the commercial laws that are codified in the laws of Puerto Rico. That's the mix. And then the judiciary, the Supreme Court, incorporates common law doctrines through the interpretation of the cases, and one way to put it, as a federal judge, I'm going to cite a federal judge that said this in one of his decisions, because a federal judge, we have a federal court sitting in Puerto Rico, is the United States District Court for Puerto Rico, and there Judge Lafitte said, Puerto Rican law does not apply the banishment of civil law, but the enrichment of civil law with common law in areas where civil law does not provide an answer. Puerto Rican law involves the absorption of common law into civil law in order to create a better legal body. So examples are, we have incorporated the delayed damages doctrine from the US, incorporating a lot of the federal case law to our case law at the Supreme Court. And we also have cases where the hold harmless common law doctrine was also incorporated through case law and interpreting a controversy between a designer and an owner, and that had an AIA contract. So you see that the Darwinian effect is definitely we are a perfect example of that. And that's what we're living. And I think it's for the better. I think it's a very rich system for the country.
Agree with you on that 100%, Mariacté. We have a time for a couple of questions that have been posted on the chat, and I will ask. Carl Circo asks, I'm interested in knowing whether civil law countries recognize concepts that correspond to doctrines known under U.S. law as economic waste and betterment limitations of damages, or the efficient breach of contract arguments. Let me ask Roberto to give us his thoughts, if he can, on the fly. Sorry.
I think that most of these doctrines, and going back to if they are similar or not, the essence is the same. We may not have these titles or these kind of doctrines, but at some point when you read some of the articles of, for example, of civil code, you notice that these theories are there. So at some point is part of the same rule of law, and that's what I will stop there.
Thank you, Roberto. Wayne Barge asks, can the panel speak to damages vis-a-vis violations of environmental health and safety protocols, standards, and regulations? I think that falls into the bucket of what you called laws of public health and order, Roberto and Mariacté. Either of you want to comment on that?
Is the question whether the codes include that regulation, or whether we have, is the question asking the difference between the common law, the civil law way of regulating that area?
I think
I'm going to try to get into Wayne's head for a moment. And I think that what he's asking is contractual provisions that deal with these risks, violations of environmental health and safety protocols. And our construction contracts have lots of provisions that deal with those issues. And are these issues among those that you and Roberto told us you can't contract out of? You have laws of public health and order, and they will override anything that you write in a contract.
well, yes, you need to go to, and that's one of the takeaways. I'm gonna advance it right now. You have to go to the attorney that specializes in that jurisdiction, because when you're talking about the civil law tradition country, because there will be not only laws but regulations issued by the agencies, the public health and the environmental agencies, that you need to verify that the contract complies with those as well. I mean, so and it cannot be contrary to what the government establishes. I mean, do you agree, Roberto?
Yes, absolutely. And these contractual obligations are tied to legal provisions. So these legal provisions, once they are breached, they breach the contract. And also when you say that they breach the contract, but they are not breaching the law, there is a connection that you have to establish. So I think that is the importance of it.
Great. Thank you, Roberto. Thank you, Mariacté. Thank you to all of my panelists. You guys have been great today, and thank you for our audience for joining us today. This brings us to the end of episode 2. Stay tuned for episode 3 of the ABA Bridging the Americas series. On behalf of Division 8 of the ABA Forum on Construction, I want to thank Amy, I want to thank Richard and everybody that has helped us behind the scenes put this together, and the effort and the time commitments that all of our Dream Team panelists have provided us. And I think the discussion has been enriching and simply super high quality. Thank you very much for your time and your efforts today, and for listening in. Amy, you want to close the session for us, please?
I think that you said it all, Jerry. Again, just thank you, everybody, both our panelists and our speakers, and please do join the ABA Forum on Construction Law and International Construction. Thanks, and we'll see you at episode 3.
Thank you very much. Have a great time. Thank you, and stay safe, everybody.
All right,
Bye.
Bye.
Bye-bye.
Thank you. Bye-bye.